Appeals Division 1 is now in session.
Thank you. Please be seated. Welcome to the Court of Appeals. This is case number CACV 130013 in the case of James Price and Teresa Price versus Kenneth Kravitz and Karen Glasser-Kravitz. For the parties' information, these proceedings will be being recorded. Hopefully in a couple weeks, if everything goes well, you will be able to see yourselves on YouTube. We have read the briefs and conferenced the case this morning, read relevant portions of the record, and we have also discussed the case in conference. Each party will have 20 minutes to present their case. Appellant, you may reserve a portion of your time for rebuttal. If you'll tell us how much time you want to reserve when you start your argument, we will try not to horn in on your time and leave you the time that you want for rebuttal. The clock on the podium tells you how much time you have left, and for appellant, if it says you've got 10 minutes left and you want 5 minutes for rebuttal, that includes your 5 minutes of rebuttal time. So, with that in mind, you may get started.
May it please the court, my name is Brian Weinberger and I am counsel for the appellants in this matter, Ken and Karen Kravitz. This appeal was necessary for two reasons. One, the trial court is now imposing a numeric height restriction on one-story homes in the subdivision that does not exist in the declaration and was not the intent of the drafters to create.
What height limit is she imposing now?
She was not clear as to what specific numeric height we must lower the roof to, which is part of the problem with the enforceability of the order, but we do know that it must be something less than 25 feet because the plans that were proposed to the trial court showed the single-story vaulted ceiling rooms up to 25 feet. So we know it must be something less than that. The second reason that the appeal was necessary is because the trial court's order does not permit my clients to know what they can and cannot build at this point and how to comply with the order. And all we're asking for in this case is for the trial court to follow its own original ruling in the case and to follow this court's decision in the first appeal. The Powell case, which has been discussed at length in the party's brief, holds that a deed restriction is to be interpreted in accordance with its intent and enforced according to its intent. The restriction at issue in this case states that homes in the subdivision cannot exceed, quote, 1 story in height. The intent of that restriction is construed by both the trial court. I forgot to reserve my time. I'm going to reserve 7 minutes for rebuttal.
Okay.
The intent of that restriction as determined by the trial court and this court is to limit the number of stories on homes in the subdivision, not the numeric height of 1-story homes. That's been the position of the appellees throughout the 5 years of this litigation, and we would submit they're judicially stopped at this point from taking a contrary position. In its ruling, the trial court drew a deliberate distinction between tall 1-story homes and multi-storied homes. It stated that there, quote, is a distinct difference between a one-story home with vaulted ceilings and 2-story homes with windows, doors, and a balcony. Appellee's position throughout this case has also been that 1 story in height means 1 level of occupied living. So when the trial court enters its original order that we remove the, quote, space between the 2nd-story floor and the ceiling, the Kravitzes understand they cannot have more than 1 level of occupied living and that a single-story room with a vaulted ceiling will be fine. The plans the Kravitzes then submit to the trial court show the 2nd-story floor removed, leaving 2 single-story vaulted ceiling rooms, one being the master bathroom and one being what we call the new room. The very kind of rooms that the trial court itself said were distinguishable from 2-story rooms. No longer were there any second levels that could be used for occupied living. There was nothing even close. The new room and the master bath were identical to other sections of the Kravitzes' home, such as their family room, that were single-story vaulted ceiling rooms that Applebee's never even argued violated the deed restriction. If we built the home today from scratch with those rooms as we proposed them to the trial court, there'd be no argument that they violate the deed restriction. And the plans submitted by the Kravitzes complied in all the other respects with the particulars of the trial court's order, that is to remove the staircase leading up to the area over the master bath, the door leading into that area, and the balcony leading out from the level over the garage. But when the Kravitzes brought plans to the court and to ask for the court's approval of them, the trial court moved the goalposts and issued an order that went well beyond the parameters of the deed restriction. Everyone, including Applebee's and the trial court, agree there is no numeric height restriction contained in the declaration. And if you ask Applebee's during their presentation, I doubt highly they'll be able to point you to one. There's no evidence or finding of any type in the record that any part of the roof line of the Kravitzes' home violates any numeric height restriction or height restriction contained in the declaration. We now have, as proposed to the trial court, we now have an indisputable one-story structure with vaulted ceilings.
Can I ask you a question, Counsel?
Sure.
I'm sorry. As presently drawn, the redrawn plans, is the roof line the same, consistent height throughout the entire house?
Well, the roof line of the house has different elevations. It is, as drawn, the roof line remains where it has been. There are parts of the house that are 28.5 feet high. They're not at issue in this case. There are parts of the home that are approximately 22 feet high. They're not at issue in this case. The part of the home that is at issue in this case are two sections that presently have a 25-foot high roof line.
Is there anything about the exterior of the structure as it currently sits that compromises the integrity of the structure?
As it
In all the tearing out and all the removal, stairways and external doors and whatever else, is there anything there that subjects it to weather or excessive wear or something like that? Or is it simply the exterior of a house, the way one would anticipate seeing it, without things missing or openings that aren't closed?
Oh, no. A lot of care went into the development of the plans that were posed to the trial court to make sure that it was a structurally sound structure.
And safe and secure as it currently sits.
And safe and secure as it currently sits, and as modified, would be safe and secure. We would submit to you also the trial court's rationale for its decision appears not to be rational. The trial court reasoned that the Kravitzes' proposal to create a single-story vaulted ceiling room up to the current roof within the existing second-story space maintains the prohibited second story the declaration sought to avoid. So in other words, even if we eliminate the second-story floor and there is no longer space between a second-story floor and a ceiling, that space that was formerly above a second-story floor, the air, still constitutes a second story. In other words, a one-story room with a vaulted ceiling now can be actually a two-story room if it is too high. And we would submit to you that's wrong-headed reasoning. Which brings us to the issue of enforceability, or simply where does the trial court's ruling even leave us? The material terms of a deed restriction, or in this case an order implementing a deed restriction, need to be clear enough to tell a homeowner what they can and cannot do with their property. We had an order reviewed by this court that was clear enough to tell the Kravitzes what to do. The Kravitzes were told you cannot have doors leading into these upper spaces. You cannot have staircases leading up to these upper spaces. You cannot have balconies leading out from these upper spaces. They were told that a single-story room with a vaulted ceiling was okay, just not a two-story room where there was another level of occupied living. Those things were clear enough to tell the Kravitzes what they could do with their property, and in fact were clear enough for us to develop plans that we could submit to the trial court. But not so with this latest order, because now the trial court has ordered something she didn't originally order, that is the roof line be lowered, but to what height? Once the roof line is demolished and the walls are torn down that support the roof, the walls have to be rebuilt up to a certain extent in order to support a new roof. But again, to what height? What's the yardstick? What's the measurement? There's nothing to give us any guidance on that. The Phoenix City zoning ordinance allows homes in the subdivision, or in this zoning area, pardon me, to be built up to 30 feet in height. But oddly, that'd be 5 feet higher than the structure that has been proposed by the Kravitzes. If the Kravitzes were to build the house now, lower the roof line to 22 feet, 3-inch difference, which would match another section of their house that nobody argued violates the declaration, then what do we do if the trial court then tells us that that is too high, that that maintains the prohibited second story that the declaration was intended to avoid? And how even does the trial court make that determination? Putting aside how we can make the determination, how does the trial court even make the determination? There's no measuring stick for either us or the trial court to use. And if we can somehow get past the height issue, the court then has to tackle the issue, or rather the Kravitzes have to tackle the issue of what then constitutes a reasonably proportioned roof. That seems on its face to be an aesthetic judgment that trial courts are not typically in the business of making. Do we need to bring contractors in to testify as experts as to what is a reasonably proportioned roof? And again, based on what? What would any expert have as a basis to make those arguments?
Is there a state standard at any level? Your declaration of restrictions doesn't address it.
No, the declaration does not.
This is in what municipality?
This is in Phoenix.
Does Phoenix have a standard for these issues?
No,
Does Maricopa County have?
not to my knowledge, Your Honor.
The state have?
Not to my knowledge, Your Honor.
It has not been addressed in the litigation to this point?
No, it was never addressed. Again, because the litigation is always focused on, is there a second story on this house? Not the numeric height. I mean, we can go through the pleadings, we can go through the arguments. Again and again and again, the argument has been from Applebee's, the numeric height doesn't matter. It's just the number of stories on the house. So the just result we would submit to you, and the one that moves this case toward a conclusion, is for this court to reverse the trial court's ruling and apply the law of the case, which is the law as announced by this court in its memorandum decision. I mean, the trial court says to the Kravitzes, hey, if what you had here was a single-story room with a vaulted ceiling, that would be, quote, 1 story in height. That would be okay. And then when we bring plans to the trial court that depict just that, trial court says, well, no, now a single-story vaulted ceiling room can actually be a second-story room. And we would submit to you that's fundamentally unfair. We know what a story is, or at least there are sources to which we can turn to determine what a story is. There's a yardstick. There's some kind of something to measure it by. The only issue under the terms of the trial court's original order and under this court's decision is whether or not there was a second story on the home. Now, because Applebee's didn't even argue below that the master bathroom as reconfigured or the new room as reconfigured were second stories, okay, we would submit to you, you can reverse the trial court's order completely. But at a minimum, we would ask this court to remand to the trial court with instructions to determine simply whether or not the plans as proposed by the Kravitzes include a second story. Then we're at least on the path to some kind of resolution. Under this order, we could be litigating this for 7 more years. That's all I have right now.
Let me ask you, you've got a minute and 30 seconds left. So the work hasn't been done on the home, is that
No.
correct? And so you have now taken, or the proposal is that what you're calling mezzanines or lofts, or the proposal is that those all come down, that the staircases come off inside and out, and then that door that went into that could come off. Is that correct?
Correct, but just to be clear about what we say when we say it will come down, what will come down is the structure that used to serve as a floor
Right. That's what I'm
for
talking about.
the upper space.
Right.
That's what will be coming down. And all access, and this was all in the evidence, all in the record before the trial court, there's no way to access this little sliver of space in the master bathroom, nor is there any way to access the space above the garage except through a scuttle hole, which has to be there by code. It is unlivable. There is no services to be provided to it, heating, air conditioning, anything of that sort. I mean, it is not livable. And in the case of the new room, there's no space at all. And in the case of the master bathroom, there's effectively no space at all. That could be, between a second-story floor and the ceiling.
Thank you very much. We'll
you.
reserve the remainder of your time for rebuttal.
Good morning. Dax Watson for the Appleese. I'm here with Emily Mann from my office. Jim and Teresa Price are here as well. What's frustrating about this, Your Honors, is how long this has been going on. This lawsuit was filed in 2008. At the original return hearing, regarding the injunction. The first judge on this case said, look, if it all has to come down, it all has to come down. You run the risk of someday a court ordering you to pull down the second story. We go through a trial, a 4-day bench trial, with a very accomplished and excellent judge. She says it has to come down. We come here. Judge Orozco, you wrote the opinion. It has to come down. And yet we're still here. And what they want to do is reverse engineer this case. They didn't build a 1-story house that was 28 feet high. They built a 2-story house. A judgment was signed that said they have to remove everything from the ceiling over the garage and the ceiling over the master bedroom has to be removed. They now want to come in and say, well, wait a second. We want to modify. We don't want to remove. And we believe modification fits within the definition of remove by the plans that we proposed. Problem with that,
so
Judge.
Counsel, is it your position then that this, what's been characterized as unlivable space over the garage and over the house was formerly the second story that is now been reduced to what they characterize as unlivable space is the second story?
No, I don't believe it will be a second story at that point, at least on one of their plans. We should make sure we're clear on this. Over the master bathroom, they do plan on removing some of the ceiling and building a structure to make it vaulted. Over the bathroom, or no, I'm sorry, over the garage, they just plan on moving over a wall, and there's still going to be a large space that someday somebody could do something with for sure if they wanted to, which brings into a question of how do you police that this is how it stays. But I guess our bigger position, Judge, is what's fundamentally unfair about what is going on here is we tried a case on whether or not they had a 1-story or 2-story house. We won that case. They were told to remove that second story by the trial court and by this court and through your opinion. You were very careful in your opinion, Judge, to define what they had to remove. You were very careful when you looked at Webster's dictionary and said, look, a story is everything from that ceiling/floor to the next ceiling. And then you said remove it. They got that order, and instead of removing it, they go to the judge and say, hey, well, this is what we'll do. And then they come in here and argue and say, well, no one ever argued whether or not a 1-story really tall house would violate the deed restrictions. Of course we didn't argue it because they built a 2-story house. They now want to try that issue when that was never an issue in the case by how they want to modify the house. They didn't build that house. This is fundamentally unfair. It's improper. We raised in our brief, there's also a huge issue is whether or not this court even has jurisdiction over this appeal, because there was no reason why that issue couldn't have been raised when they appealed up the first time. The only thing they had to say is that their interpretation of the judgment and the word remove allows them to modify this into a 1-story house. They didn't appeal that. Since they didn't appeal it, they can't now come and appeal that to you today. So what that basically leaves us with then is Judge Willett's most recent order, which addresses this idea of a reasonably pitched roof. What she has ordered is pretty simple. Pull down the second stories, and if you want to put up a reasonably pitched roof that is consistent with the other houses in the neighborhood, then do it, which would then enforce a declaration, which would then enforce the law of this case. She didn't create another issue. She was actually trying to be helpful to them. They've grabbed onto that and now come in and say, look, we could have built a 1-story house that was 30 feet high and everyone's conceded that. No one's conceded that. This court didn't rule that. The lower court didn't rule that. We were in a 2-story house case, and now they want to say, hey, we're going to build a 1-story house that's tall, and we want to modify this house, and you have already sanctioned that. That's just not true.
Counsel, go ahead.
What part are you objecting to? Is it the removal of the second story? Is it the covering up, making? It sounds like they've now made an attic in the garage where you.
Well, they've done nothing yet, Judge, just so you know.
But they're proposing. I'm sorry.
Sure.
That they're making an attic that can only be accessed through a scuttle. What part is it that you're objecting to?
We're objecting to the fact that they want to keep this house as it is and just modify the interior. You ordered to remove the second story. And why this is really important, Judge, is I'll point you to your opinion. No less than 2 places you noted there's a quiet enjoyment issue here, that this house, as structured with these 2 stories, impedes upon their quiet enjoyment. They want to say, well, it's no big deal anymore because we're going to take out the windows, things of that nature. That wasn't how your opinion was written. Your opinion also focused on views of Camelback Mountain, just the general enjoyment of the house that they have, so they don't have this giant monstrosity of a house next to them. So our objection is they were ordered to remove the second story. They don't want to remove the second story. They want to keep the roof line exactly as it is, do some work inside, and say we've now complied. That wasn't what was ordered. That wasn't what this whole case was about. We've been litigating this for 6 years. The judgment came down over 2 years ago, or almost 2 years ago, your appeal, on April 19th. We still have the exact same house there. The quiet enjoyment that you referenced no less than 2 times in your opinion is still being impacted upon and will continue to be impacted upon if they don't comply with a very simple order. Because I remember, Judge, what's really important is the order that you affirmed of Judge Willett said they were to remove everything above the roof line of the garage and above the roof line of the master bathroom. You affirmed that. You said that's what they're supposed to do. They don't want to do that. They want to come in and modify. That's not consistent with the order that you affirmed, Judge. And that's our objection, is they want to do something completely different than you've already said they have to do. They want to come in and now litigate, well, what if we built a one-story house that was 30 feet? Would have that violated the deed restrictions? They don't get that bite of the apple. They could have appealed the judgment and said removed means A, B, C, and D. They didn't.
So what I hear you saying is if they had originally applied for the existing footprint and had asked to go up 25 or more feet, they could have done that.
No, I don't believe they could have, but that wasn't what was litigated. Judge Willett didn't render an opinion on that.
There's nothing that rendered that invalid under the DORs, is there?
Well, it depends if we wanted to get sidetracked into what one story in height means. I mean, if you build a 2-story house, isn't that just from logic more than 1 story in height? And that's effectively what they want to do now, is take a 2-story house, remove some portion of it, and make it 1 story in height. How could it be if it was originally 2 stories?
But you're infusing a second definition in there. The difference between a 2-story house and a 1 story in height house.
I agree, Judge, but that's what the actual declaration says.
It says what?
It says you are not permitted to build a house that exceeds 1 story in height. That's exactly what it says in the deed restrictions.
But it doesn't define what 1 story in height is.
No, but you're also talking about a deed restriction that's over 50 years old, and as Judge Orozco did when she wrote her opinion, she looked around the neighborhood and looked at the other houses and how they were traditionally built at the time, the fact that they were trying to protect views of Camelback Mountain, things of that nature. Yeah, they weren't careful enough to put in an actual numeric number, but as this court also did, this court looked at the King case from California, said that there's nothing wrong with that restriction. It's consistent with Powell for us to now interpret what the original drafters meant, and that this particular house with 2 stories was definitely out. Again, our frustration is we're now trying to reverse engineer this. They didn't build a 1-story house with really pitched roofs. They built a 2-story house. They were told to remove both of those second stories. Now they want to come in and say, well, oops, we could have built this 1-story house and everyone agrees that would have been allowed. That was never litigated. They now want to litigate an issue that didn't occur. They want to reverse engineer their house to say we built a 1-story house and say that you should sanction it, when this court already ordered that they have to remove the second stories almost 2 years ago. Unless the justices have any other questions, then I think or the judges, I'm sorry. I think I'm done. Did you have a question, Judge?
No.
Okay.
We
Great.
just
Thank you.
elevated us to justices.
I know, I apologize.
That's okay.
I look at you that way.
Yeah. We look justice so that we affirm.
Thank you.
Okay. Thank you.
I'm not going to presuppose to tell the court what it said or didn't say in its previous memorandum decision, but here's what is clear from the court's previous memorandum decision, that the intent of the restriction was to limit the number of stories on the home, quote, not necessarily a specific numeric height, unquote. That is what was affirmed. There is nothing in the language of this court's memorandum decision that says tear down a second story. And more importantly, there's nothing in the trial court's original order that said tear down the second story. In fact, the trial court's original order presupposed that the structure itself, the walls and the roof line, would remain intact. She called out that the Kravitzes needed to remove a staircase leading up to the upper level. She called out that we needed to remove the door that led into an upper level. She called out that we needed to remove a balcony that led out from an upper level. If she had intended by her original order to remove everything above the ceiling, which is the appellee's position, it would have made no sense for her to call those things out. Because obviously if the structure was coming down entirely, which is what appellee's position is, then all that would have been, those things would have been moot. The substructures would have been moot. So clearly, there was evidence of an intent by the trial court originally that that structure was not to come down. And what is fundamentally unfair and what we're arguing about is the fact that the court changed what she ordered. And there's no way to read the trial court's order, the latest order at this point, as anything other than creating and enforcing a numeric height restriction. Very significantly, in response to Judge Winthrop's question, counsel concedes that the spaces that are left under the proposed plans are not second stories. That ends the inquiry. If the issue here, as both courts have said, is whether or not this is a one-story house or more than a one-story house, and the only issue is stories, and now appellees concede that there are not stories, second stories left over after these plans that have been proposed, then as a matter of law, the inquiry is over. The other issue the counsel raised that is very important to address is this issue of privacy and quiet enjoyment that Your Honor did mention in her opinion. I don't think counsel was accurate in the way he described what that issue was. The issue of privacy and quiet enjoyment as framed by the trial court in its original order was this, quote, defendant's second story permits the defendants to enter and exit the second floor by an interior and exterior staircase and windows which provide individuals with a clear, unimpeded view into plaintiff's backyard. She continues, plaintiffs can now observe the comings and goings of defendant's family on 2 floors of living space overlooking plaintiff's backyard. All of those, that was her rationale for how there were quiet enjoyment issues or privacy issues that were implicated by the deed restriction. All of those issues were eliminated by the proposed plans that the Kravitzes submitted to the trial court. There's no second floor of living space, therefore appellees are not going to be watching the comings and goings of anyone on a second floor of living space. There are no staircases anywhere, inside or outside. There are no windows that can be used to view into the appellee's backyard unless somebody was, 18 feet tall or 19 feet tall and could look through what are now just going to be windows used for light. All of those issues were eliminated by the proposal, which again is why this appeal was filed. We were given a standard to follow, we followed the standard, and now the standard has changed. And it's changed in a way that is not supported by the declaration itself. Appellees appear to argue that, well, if we had built the house originally in the configuration as we proposed it to the trial court, even though that would have been compliant with the declaration, it's irrelevant because that issue was never tried. I would suggest to you that's the core of the issue. The only issue before the trial court and this court is whether or not this structure offends the declaration. And it only offends the declaration if it has a second story. Appellees concede there is no longer a second story as the house has now been proposed. The trial court defined second story as not a one-story room with a vaulted ceiling. So we have complied in all respects with every single item that was contained in the trial court's order, including those that related to the issue of quiet enjoyment and privacy. Counsel also argued that the trial court's original order was that we, quote, remove everything over the ceiling of the garage, unquote. That is not what the trial court's order originally said. As I discussed a moment ago, the order presupposes that the structure itself will remain and only the access to the structure was going to be removed. Unless Your Honor has any additional questions, those are the points I wanted to make in rebuttal.
Nope, that is it. Thank you.
Thank you.
We will take the matter under advisement and issue a ruling in due course. We are going to adjourn briefly to let the other case get set up, and we will be back.